Legal Fallout presents. He threw it in the trash. A plain, white envelope. No return address he recognized. Looked like junk mail. 43 days later, he no longer owned his house. His name was Marcus Webb, 47 years old, electrician, father of 2. 11 years in that house in Dayton, Ohio. Never missed a mortgage payment. Never caused a problem. He was not a careless man. He just didn't open one letter. And that was enough. Inside that envelope was a legal notice from the county court. A lien had been placed on his property, filed by a debt collection company, over an unpaid medical bill from 2019, $4,200, from an emergency room visit that his insurance was supposed to have covered, that he had assumed was handled. It wasn't. The insurance company had denied the claim. The hospital sold the debt to a collector. The collector filed for a civil judgment. Marcus never showed up to contest it, because he never knew it existed. The court ruled in the collector's favor by default. The judgment became a lien against his property. Automatic, legal, completely invisible to Marcus. Until that envelope arrived, which he threw in the trash, because it looked like junk mail. Now here is where it gets dark. A lien on your property is not just a note on a file. It is a legal claim against your most valuable asset. And in Ohio, if a lien goes uncontested, the lien holder has the legal right to force a sale. Not suggest a sale. Not request a payment plan. Force a sale. The process moves whether you participate or not. Notices get sent, deadlines pass. Hearings are scheduled. And if you don't show up, the court doesn't wait. Marcus had 30 days from that letter to respond, because he didn't read it. A second notice arrived, certified mail. Marcus signed for it, set it on the kitchen counter, and forgot about it for 2 weeks. By the time he opened it, he had 7 days left. He called a lawyer on a Thursday afternoon. The lawyer went quiet after reviewing the timeline. Marcus, we're out of time. The debt that started all of this, $4,200, had now grown to $9 million with legal fees and interest. Marcus didn't have $9,800 liquid. His equity was in the house. The house that was already in the process of being forcibly sold. He filed an emergency motion. The judge reviewed the case, acknowledged that Marcus had never tried to evade the debt, acknowledged the insurance failure, and then upheld the sale order, because the law had been followed. Every step, every notice, every deadline. The system had not failed Marcus Webb. It had worked exactly as designed. He just hadn't known the rules. His house sold at a county auction 6 weeks later. His daughter cried the night they left. His son didn't say a word. Marcus sat in the parking lot for 40 minutes before driving away. 11 years gone because of one letter. This is not a rare story. It happens in every state, every county, every year. To people who pay their bills, follow the rules, work hard. Medical debt is the #1 cause of unexpected property liens in the United States. Most people who receive a civil judgment notice never respond, not because they don't care, because they don't understand what they're holding. The legal system does not require you to understand it. It only requires that it notified you. After that, the clock starts. whether you know it or not. So open every envelope with a government seal. Open every certified letter the same day. Any notice mentioning your property, a judgment, or a court date. Call an attorney before the week is out. Because the system moves fast, quietly, legally, without hesitation. And it does not care that you thought it was junk mail. Marcus Webb thought he had more time. Legal fallout. Know the law before it's too late.